I want to address one issue that you mentioned, and Mr. Edlow mentioned as well, and that is the provisions in the law related to past criminal behavior. Dangerous criminals are not eligible for status under the Dream and Promise Act. In fact, all of the bars that apply to immigration and naturalization automatically apply to anyone who's seeking to become a citizen under the Dream and Promise Act. It also bars individuals who are guilty of any felony, any 3 misdemeanors, or any crime of domestic violence. Now, I will readily concede that in 20 years and 20 at least different versions of this bill, there have been a lot of different definitions. But that is the standard of H.R. 6 that we are considering today. The notion that somehow, as Mr. Edlow said, we are going to give amnesty to criminal aliens couldn't be further from the truth. I'm sorry that you said that in the record because it doesn't reflect the reality of this bill. And I might also say that to call Dr. Mejia and Mr. Pontieu somehow flagrant violators of the law is to ignore the obvious. Mr. Mejia had very little to say when his family decided to come to this country. Mr. Pontieu came here under extraordinary circumstances in his own country. They don't really fit in a definition of flagrant violators of the law, as I see it. And that's why the DACA population has been considered in a different context as others. In terms of the current situation at our southern border, as Mr. Rodriguez said, it is challenging, and I could certainly give a defense to what we face today. It's not the first challenge. And if our standard on changing any immigration law is that we must have perfect compliance of all other laws, we'll never do anything. I think that would be a mistake. Personally, I support comprehensive immigration reform. Join the Gang of Eight, put the bill to the floor, it passed the Senate. I believe we should consider the fact that our immigration system is broken at this point. And the fact is, it didn't pass the House of Representatives. It did not become law. In terms of where we go from here, I've accepted Senator Cornyn's invitation, rather than challenge, I'll call it, to act on the southern border as part of any conversation that we have about any aspect of immigration. I think that is a good faith effort to try to find some common ground on a very challenging situation. Dr. Mejia, before we go any further, have you run into obstacles in terms of your medical licensure and such because of your undocumented status?
Thankfully, I have not. In the state of Illinois, I have not, but I'm sure that I would run into issues if I want to expand my medical license to other states in the United States.
So it's state by state in terms of your status?
That is correct.
And you, thank goodness, are going to continue to practice in the state of Illinois? No. Yes?
Yes.
Well, that is good news. Mr. Rodriguez, you've heard the testimony of Mr. Edlow and others about the situation with those with criminal status. I can't recall a version of the DREAM Act or DACA that has not included a bar to those who are guilty of criminal misconduct.
That is correct from my understanding as well, and I think your point that the existing inadmissibilities that run across all of immigration law will continue to apply here as well. Those are structured specifically to exclude felons, serious criminals, even in many cases, those who've only committed one misdemeanor.
Yeah. That is the case. With TPS, I believe that is exactly the case. The TPS holders, they make ineligible anyone with one felony or more than one misdemeanor conviction under the bill. And there's no waiver for a crime that makes someone eligible for TPS included in the bill. So we maintain these standards as we must. And if we expect any bipartisan support for this bill, we're going to have to watch that very carefully. I'm sure that's an important consideration.